Our next session is the second part of our Legal Focus series. Michael Gruden, partner at Crowell Moring, will guide us through the full spectrum of legal compliance considerations, from staying on top of contract obligations and reporting requirements to avoiding costly missteps like misrepresenting your controls. Drawing from nearly 15 years at the U.S. Department of Defense and Department of Homeland Security, Michael represents some of the nation's largest defense contractors and tech companies in navigating data security requirements and responding to cyber incidents. He sits on the CMMC Accreditation Body Appeals Board, is a registered practitioner for CMMC, and is a certified information privacy professional. This session will equip you with your practical strategies to keep your CMMC program on track and protect your organization.
Thanks for joining me here today. Happy to talk cyber compliance and related risks that you should think about from a legal perspective. I wanted to start our conversation today by thinking through a cyber retrospective. And what I mean by that is looking back over the last 10 years to see where we started and where we've come from today with regards to CMMC. When we look back over the last decade, there's been significant development from the Department of Defense with regards to how they're regulating cybersecurity and particularly controlled and classified information. Starting back in 2013, the DoD released a DoD cyber clause referred to as the Defense Federal Acquisition Regulation Supplement, also known as DFARS 252-204-7012. That particular clause was the safeguarding cover defense information and cyber incident reporting. This was the sort of premier seminal clause that was introduced, that introduced those core cybersecurity requirements that we now today are seeing implemented in CMMC. And that specific standard is referred to as NIST 800-171. NIST stands for the National Institute of Standards and Technologies, and the specific standard includes 110 security controls. They overview everything pertaining to access control, multi-factor authentication, physical security, personal security, and about 10 other control families that comprise the suite of cyber standards. Now, not only did the clause include adequate security provisions, such as implementing this suite of controls, NIST 171, it also included a requirement for cloud security. And what we mean by that, if there was a regulated data that was being stored in the cloud, there was a separate requirement to ensure that any cloud solution would also meet a separate standard referred to as FedRAMP. And that stands for the Federal Risk Management Program, and that the requirement would be that you have that your data stored on a FedRAMP moderate baseline or its equivalent. And so that was the leading requirement that was around for a good 5 years. And the DoD relied on contractors to implement that. And the way that they met that requirement was to have a written documentation that described how they implemented all 110 security controls. And that document was referred to as a system security plan. One thing that was unique under the DFAR 7012 clause was that there was not a requirement, though, to fully implement all 110 security controls. The DoD actually created another mechanism to allow for controls that were not fully implemented and referred to that as a plan of action and milestones, or also known as a POAM. And what the DoD intended was that for contractors that had not implemented all of the controls, they could have POAMs that were open for an undetermined amount of time. And as long as those were closed out within a certain period, that was sort of made you fully compliant with this DFAR 7012 clause and in spirit, the NIST 800-171 standard. The DoD recognized, however, over a 5-year period, that a plethora of cyber incidents continued to occur, and that essentially this honor system of implementing the controls through this written documentation was not sufficient. And what happened was around January of 2020, the DoD originally introduced the inaugural CMMC 1.0 program. Some of you might be a little surprised to know that was around for the last 5 years. But again, when that was originally released, it looked entirely different from what it looks like now. But again, due to various industry comments and feedback, the CMMC rule was shelved and it was reviewed internally by the DoD, and they made various revisions and then later released kind of the CMMC 2.0 that we see now. But around that same time frame, the DoD released several other DoD contract clauses, specifically DFARS 252.204-7019 and DFARS 252.204-7020. Those are the NIST Basic Self-Assessment Clause and solicitation provision. And what that required was for industry now to assess their own compliance, to sort of look internally, determine how they've implemented those NIST Integer 171 controls that I was just mentioning, and then score themselves based upon how many controls are implemented using a separate rubric or scoring methodology referred to as the DoD assessment methodology. And based upon that, whatever score was derived, there would be a requirement to then upload that score into a separate government portal referred to as SPERS, the Supplier Performance and Risk System. In addition to these requirements, the 7019 and 7020 clause also avail the government the opportunity to conduct on-site audits of contractor compliance. This was, again, a significant shift from the DFAR 7012 clause that did not include any type of audit rights on the government, specifically as it pertained to cybersecurity. But again, under the 7020 provision, we began to see many companies actually have these government audits where the government would come on site and review control implementations. These were conducted through a branch of the Defense Contract Management Agency referred to as DIBCAT, the Defense Industrial Base Cybersecurity Assessment Center. And DIBCAT conducted these either medium assessments, which would be conducted virtually, or high assessments where they were actually coming on site and reviewing even physical access controls, and et cetera. That was notable because, again, there was a stark sort of transition, if you will, of not a sort of just an honor system, but a trust but verify component. That again was sort of beginning to sort of methodically move towards what we're seeing now in the future state with CMMC 2.0. However, one thing we also want to note, though, is that around 2021, there was a new initiative that was unveiled by the Department of Justice, referred to as the Civil Cyber Fraud Initiative. And with regard to that, the DOJ announced that it would use the False Claims Act to enforce cyber noncompliance. That's notable because we've seen over the last 5 years since that announcement, a myriad of DOJ enforcement activity within the defense industrial base of contractors that have not fully implemented these controls as the government intended them to be or in compliant with these contract requirements. We'll unpack further in a little bit why that is so critical, but wanting to sort of note from, again, a timing standpoint of when that was introduced and where we began to see more activity. So after that point in time, CMMC 2.0 was released about a year ago now. And within that, there was the CMMC program rule, which was based in the 32 Code of Federal Regulations. What that enabled was actually for the program itself to be finalized, and it allowed certified third-party assessment organizations to begin conducting CMMC assessments. And what that also meant was that companies themselves could also obtain CMMC certifications. And again, for those of you that maybe missed some of the other prior presentations, the unique aspect of CMMC is that going forward for future contract requirements with the Department of Defense at this point in time, that contract awards will not be awarded to companies where they don't possess a CMMC certificate at the requisite level that's noted in the solicitation and ultimately in the contract award. So that's a brief overview of sort of where we are and where we're going. But now we wanted to sort of unpack some of the key differences between the CMMC 2.0 program and these previous cyber regimes that I was just overviewing. The first notable difference is the assessment criteria. As I mentioned earlier, there was a separate assessment methodology that was based off of that same cyber standard NIST Standard 171. And to conduct that assessment and the same assessment that DIBCAT used, it was built solely off of an assessment guide that correlated to NIST 800-171. That still maintains, and again, 800-171A as an alpha, that assessment guide is still utilized under CMMC. However, in addition to that, there are specific assessment and scoping guides of CMMC that provide additional specificity and interpretation of how the controls are implemented, as well as CMMC-specific practices that are included that are not fully in alignment or identical to that included by 171A. Another notable difference is the inclusion of CMMC asset categorization within the CMMC final rule. What we mean by that is under the CMMC program, there's a way to sort of define and group your different categories of information and technologies. And what we mean by that is depending upon how you categorize your network, your data, and the systems that are handling that data, they will be assessed against certain standards. And in other instances, they will not be assessed at all. The most common category of asset categorization is a CUI asset, and essentially that's an asset that's intended to process, store, or transmit CUI. Another category is a security protection asset, where again, the intent of that type of solution is only to perform some type of security mechanism, thinking, for an example, like a firewall or a router or a switch. Things like that will provide some type of endpoint detection. In addition to that, there are contractor risk managed assets that again are typically considered out of scope and wouldn't be reviewed as stringently as a CUI asset. So all that to say, depending upon how your various solutions are viewed, it would actually need to meet a certain type of cybersecurity requirement. And again, it would be assessed differently, ultimately by an assessor, and ultimately that being the certified third-party assessment organization or the C3PAO. The other key difference that we really wanted to call out here under the CMMC program to be mindful of is the concept of attestations. And what we mean by that is there's a new requirement that a senior official that is responsible for compliance for the cybersecurity of the organization to provide an affirmation that the controls from CMMC were fully implemented, are accurate, and complete. And in addition to that, this is not a single affirmation, but affirmations are required after every assessment, both assessments that are conducted by the company themselves as self-assessment, which will be required by most after the CMMC final rule is finalized, likely this fall. But in addition to that, after any plan of action and milestone are closed out, and every year thereafter. And what we mean by that every year thereafter is that even after a CMMC certification is obtained, there is still a requirement every year annually to attest and affirm that the controls are still fully implemented and accurate. This is notable, again, from a compliance standpoint and from a legal risk perspective, is that, again, when we think about DOJ enforcement action and how the government is enforcing compliance with CMMC in the future and looking forward, they're going to actually really look critically at, are the controls implemented at the time of the assessment, but then also 1 year after that and the following year subsequently, if the controls were still consistently implemented and are being met. And again, that is an area that companies should be mindful of, that again, if the controls were not implemented or not maintained, there could be a degradation of the security such that, again, additional risk could be presented for the company, where we may be inadvertently creating an affirmation saying, yes, we're good, we fully implemented everything, but in actuality, there could be some gaps in our environment. That's why it's really important to both align with vendors and consultants and attorneys that understand this space and can actually pressure test and conduct privileged assessments to help you understand whether or not your controls have been fully implemented and are still being maintained and implemented even thereafter their initial implementation. So that's something to think about from a compliance perspective. But we're wanting to transition now into areas of additional investigation and liability for companies to be mindful of as they're thinking through their cyber compliance hygiene and posture. Something else to think about is, again, the concept of inaccurate self-assessments. Some of you might be familiar, if you have followed some of the recent settlements with regards to the Department of Justice and the Civil Cyber Fraud Initiative, is that many of the cases that we have seen the government bring forth enforcement actions that have resulted in settlements that are publicly disclosed are all contingent upon companies that have misassessed their own compliance. And what I mean by that is they have actually completed at some point in time an inaccurate assessment of their own compliance and documented that. Most of those have occurred through the upload of that self-assessment that I was referring to earlier under the D4 7020 requirements and uploading that score and disperse the supplier performance risk system. But so too, that same requirement will likely continue under the CMMC 2.0 regime, because again, there is an assessment likely for all companies once the final rule occurs for the 48 Code of Federal Regulations CMMC rule, which again will codify the clause itself. Once that comes into effect, likely this fall, companies will need to then assess themselves. And again, therein lies a lot of risk that companies may be inadvertently interpreting and or applying the controls. So you might have some false positives there when we get to the concept of sort of fully complying with CMMC. There too is something to be mindful of really understanding, do you fully comprehend and know how the government is expecting individual controls to be implemented? How you actually scoped your network in a way that you have defined your boundaries, because again, boundary definition is so critical from a CMMC compliance perspective. And what we mean by that is, again, if you have your regulated data like your CUI and you've not accurately defined the boundary, the controls that you're assessing yourself against may not be fully implemented if you think that you're applying them only to a smaller subset of your environment, when in actuality it may need to be met more broadly or throughout your entire enterprise, depending upon how you've defined your boundaries and your network and the scope of your compliance. Looking now to some of the recent settlements that we've seen from the Department of Justice that are relevant, we wanted just to flag a few, and there's many out there that you can refer to and that we can cover in subsequent discussions of how the government has sort of brought forth these actions in areas that they focused on. But like I was mentioning earlier, many of these have occurred initially where a company has assessed themselves incorrectly or represented to the government they're fully compliant with their various cybersecurity requirements. In addition to that, oftentimes what we've seen through discovery and even in leading cases that we have represented clients on that are also quite notable in sort of size and in settlement amounts is that oftentimes these companies have had assessments conducted by an external consultant, but those assessments were not conducted under attorney-client privilege, and that's really a critical distinction because as a result, through the Department of Justice and the discovery process and through a litigation and investigation, the government actually obtained those documents that were conducted by those external third parties, meaning any type of assessment findings, reports, recommendations would be fair game for the government to review. And we've seen specifically through obtaining those external assessments, the government has sort of found those inconsistencies where a company had previously determined that they, or even intimated that they fully met all their controls and requirements as dictated by a contract. However, a third party had separately validated that they were not fully met. And so again, that disparity, that disconnect has been sort of viewed as a misrepresentation by the government in most instances, and therein lies significant risk, and that's where they're bringing forth a lot of these enforcement actions for companies. So that really highlights the importance of being mindful of having privileged cybersecurity assessments when you're going through a readiness assessment for NIST, for CMMC, or frankly, any other cyber contract compliance. It's important to consider utilizing either a law firm to exclusively conduct that assessment or partnering with another external consultant to engage into a tri-party agreement such that then the law firm would be overseeing and directing that for the furtherance of legal services. That's critical to sort of mitigate potential risk, where we're seeing companies do that both for CMMC readiness as well as for their official C3PAO certified assessment. But some of the other leading cases that we're seeing that are notable to be mindful of, because I think they're really instructive, are some other recent cases that are focusing on not exclusively on a prime contractor, but also their subcontractor. And so one case that was settled about a year ago was for Guidehouse Incorporated and Nan McKay and Associates. Within that, there was findings as a result of a data breach, actually, that cybersecurity testing was not performed not only by the prime contractor, but also the subcontractor. And what we saw in this settlement was that there was a settlement not only for that prime contractor for $7.6 million, but the same for the subcontractor themselves for $3.7 million. This is notable because this was the first case that we've seen in this sort of compendium of settlements and disclosed cases from the Civil Cyber Fraud Initiative that actually invoked a subcontractor. Previously, we've only seen activity and focus only on a prime contractor, but this was the first time that a subcontractor was also brought into enforcement and also resulted in a settlement. And I think that that's really notable for companies to think of that may not be prime contractors, but maybe lower down the defense industrial base supply chain. And to sort of note that, again, subcontractors, suppliers are not immune from enforcement. They're not immune from these cybersecurity requirements. And so if as part of your course of business, you are handling regulated data, if these contract clauses are being flowed down to you, then there is an obligation to fully meet these requirements. And if they're not met, then that in and of itself is creating risk not only for you, but as well as for your prime contractor. And so again, that risk flows sort of both ways, both up and down. So that's a notable case that we wanted to flag for that reason. Another aspect that we wanted to focus on too, separate from sort of just pure NIST implementation, is the concept of cloud security. We've seen multiple cases now that in part are bringing up the concept that companies are using cloud service providers or software or platform as a service type solutions based in the cloud that are not meeting the FedRAMP moderate baseline or its equivalency. One recent case about a year ago was with Penn State. One of the findings was that there was a lack of cloud security compliance and a failure to use FedRAMP moderate equivalency requirements where CUI was being processed, stored, or transmitted. More recently, earlier this year in March 2025, Morse Corporation was another settlement for $4.6 million. And that touched on multiple instances. One was pertaining to the concept of self-assessments, where again, it was found through discovery that again, there was an incorrect SPUR score that was calculated and that an external vendor, again, not privileged, not under the direction of counsel, had also conducted a same type of an assessment and determined that there was a disparity of over 100 points with regards to their compliance and that the company failed to update their SPUR score or to remedy the situation for multiple years. But in addition to that, there was a separate finding that a third-party service used for email hosting did not meet those same security requirements that were equivalent to the FedRAMP moderate baseline. We flag that to note that it's really important to understand your data, understand where it's flowing, and understand where it's being stored or processed. And what we mean by that is, you do need to track where your CUI is flowing throughout your network, both if you have an on-prem environment, but also if you have a cloud-based solutions where that data is also traversing. If that is the case, it's really critical to really vet and review if all of those solutions are meeting this FedRAMP moderate equivalency. If not, you too could be in a scenario where you're facing or at risk of enforcement for non-compliance, which I know that we all want to avoid here. From this, I wanted to transition into some strategies and best practices that you can consider to reduce enforcement risks. And this sort of touches on a concept that I was mentioning earlier, which is knowing what regulated data you own and really where it resides on your network. And again, wanting to sort of go back to the concept of controlled and classified information. For those of you that aren't familiar, controlled and classified information, also referred to as CUI, includes over 100 categories and subcategories of information. And in order for data to be classified as CUI, it has to align with a law, regulation, or government-wide policy. But sort of in its premise, fundamentally, most of those categories align under some type of law or regulation. And that's important because, again, for data to be determined to be CUI, it needs to be marked or otherwise identified initially by the government, but there also is a legal analysis to that. And what we mean by that is many clients of ours that have been handling data they were not sure whether it was CUI or not, that they've obtained kind of that independent consult to determine what data they're handling is CUI, or if they're receiving a document that is marked as CUI as a specification, are they then generating it if they're taking portions of that specification and inputting it into other systems or otherwise generating data or some other type of commodity from that originating specification marked as CUI. Those nuances really do matter. They can matter from a compliance standpoint. They can matter from an enforcement standpoint. So it really is critical to understanding what categories of CUI that you're handling, and then understand what other additional requirements may be incorporated as a result of that. And sort of one example would be if you're handling export controlled information, that category of CUI, again, if you're handling export control information under a DoD contract, it would be considered CUI. And not only do you have to meet the NIST Standard 171 requirements and the FedRAMP moderate equivalency requirements, but there's also a requirement to meet U.S. persons requirements. There are other CUI categories that so too have similar U.S. persons and other requirements in addition to what we're describing here. So again, it's really important to know what data you're handling and to know, again, where it is on your network, because that will inform the types of solutions that you'll need to implement within your network and then build out your compliance program from there. The next point to consider is knowing your contract requirements and ensure you comply with them. And what we mean by that is while CMMC is the topic and focus of not only the day or the year, but maybe probably the next few years, is that it's important to know that there are other requirements that are likely included within your individual contracts. And again, as mentioned earlier, being a former contracting officer, branch chief at the Department of Homeland Security and at the Pentagon, I can tell you that, again, your contracts typically will have other terms and conditions that might specify additional requirements above and beyond CMMC or NIST Standard 171. And what we mean by that is there could be data localization requirements, meaning that your data must reside in the United States. There could be requirements that have enhanced security requirements in addition to NIST 171. But again, you may not know that unless you're looking very carefully at those requirements. But again, those nuances and details are other areas that we've seen enforcement being brought forth by the Department of Justice. So again, just wanting to emphasize it's really critical to know all of your contract requirements and ensuring that you're following those. From there, the other recommendation is to determine what compliance gaps exist and then carefully track their remediation. It's important to, again, where you can have those privileged readiness assessments where you have a competent professional, either an attorney or partnering with an external third party where, again, the attorney's overseeing directing that, so that, again, all of those funds are insulated. But once you actually do find those gaps, that you actually plan out a methodical plan of how to close out and remediate those gaps, and also prepare your documentation for your subsequent CMMC assessment. For many of the companies that we've assisted in these types of engagements, we've noted that for some companies, they're implementing the technical solutions, but they're also lacking the artifacts that are necessary to meet a control. And what I mean by that is, again, another difference under the CMMC regime is that not only is sort of the technical implementation critical, but in order to meet each of the controls, you have to demonstrate two artifacts, or in another way stated, two sources of evidence to demonstrate how you've implemented that individual control. The first could be an interview where you're talking with IT personnel, or even a technical demonstration, but oftentimes companies are relying upon policies as another mechanism to demonstrate that a control has been met. But in these various privilege engagements where we've assessed and reviewed companies' policies, we found that they're often lacking specificity and or tailoring to actually meet these security requirements. We're aware that there are many great solutions that are available in the public domain, and other offerings where companies are sort of offering more boilerplate or policies to sort of implement CMMC requirements, but they often lack the specificity and tailoring that an assessor is looking for in order to determine that your controls are effectively implemented. So it's important to know that, again, both your system security plan and the underlying policies are drafted in a way that are innate to your organization, and that in practice, you're following what your policies and documentation state. Any disconnect there, too, can create legal risk for your company that we would want to mitigate. Another thing to think through, sort of to mitigate risk, is listen to internal concerns. And what we mean by that is, again, if there are personnel internally that are saying that we're doing things wrong or they're disagreeing with an approach, take that seriously, document it, and then consult counsel and consult, respected consultants to validate whether or not those foundings are well-founded or not. The reason being is, again, under the False Claims Act itself, there is a keep tan provision, or otherwise referred to as a whistleblower provision. And what we mean by that is that, again, many of the leading settlements and cases that are being brought forth were a result of a whistleblower going to the DOJ, and then the DOJ electing to intervene in those cases. And so that's why it's really critical to understand any type of internal concerns and then documenting those accordingly. The other aspect, again, that we want to flag is just ensuring that you're accurately reporting your cybersecurity compliance. And again, when we're referring back to those self-assessments, we've seen some clients that have scored themselves, frankly, too harshly, where they're over-interpreting the control implementation, which, again, we applaud. But again, it's important to level set that you're accurately implementing the control such that you're not underscoring yourself, but you're also not overscoring yourself. And again, when we're getting into looking future state to those affirmations, it's important that, again, even after we obtain that CMMC certificate, that we ensure a future state that we're maintaining those controls, and that we do have sort of a vigilance in place to review and to ensure that the controls are being effectively maintained kind of throughout their life cycle there. And then again, last, sort of just as a reminder, again, consider conducting these risk assessments and audits under attorney-client privilege. It's really the best way to mitigate that risk. And so again, in closing, these are some things to think through with regards to the CMMC program as we look towards implementing these requirements for companies that are looking to obtain certifications. Thanks for joining, and please feel free to reach out with any questions.
That wraps up the second part of our Legal Focus series. Thank you, Michael. We've covered the full spectrum of compliance and legal considerations, from contract obligations and reporting requirements to avoiding costly missteps like misrepresenting your controls. Armed with Michael's insights and practical strategies, you now have the tools to keep your CMMC program on track and protect your organization from legal and regulatory risks.